Just about an hour ago, a federal judge denied Mark Meadows' bid to move his criminal charges in Fulton County to federal court, ruling that his alleged involvement in efforts to pressure state leaders who overturned the 2020 election results was not a part of his official duties as a government official. It is a major setback for Donald Trump's former White House chief of staff, who sought his request on the grounds that he was a federal officer at the time of the actions that led to his indictment. It also indicates Trump himself will have a really hard time moving his case to federal court, something his lawyers told a judge this week he would still try to do. We'll have much more on this in a minute. Also today, the door flew way open on the special grand jury's deliberations for this case and the much longer list of people that were recommended for charges. Released today was the full report that led to the criminal indictment of former President Donald Trump, Mark Meadows, and 17 others for trying to overturn his 2020 Georgia election loss. It showed that grand jurors had recommended charges for 21 additional people, savage, on top of the 19 who were actually indicted. Those 21 individuals were not ultimately charged. Special grand juries in Georgia cannot issue indictments and instead serve as an investigative tool. The findings for this particular case are the culmination of months of investigation, including testimony from 75 witnesses. It's a lengthy list, and it includes some big names, such as sitting Senator Lindsey Graham, a man who chaired the Senate Judiciary Committee, as well as former U.S. Senators Kelly Loeffler and David Perdue of Georgia, who were sitting senators during the alleged crime. Senator Graham scoffed at the idea that he should have been charged in the case, saying that for the next election, he'd do the same thing.
If it ever becomes impossible or politically dangerous or legally dangerous for a United States senator to call up people to find out how the election was run, God help us all. The next election, if I have questions, I'll do the same thing.
And hopefully next time he'll get indicted. Flynn also responded, releasing a statement that described the report as more corruption by a politically motivated prosecutor, a baseless witch hunt that isn't based on the facts or the law or reality. We also learned that one of Trump's Georgia co-defendants was not mentioned in the special grand jury report. That is Mike Roman, who allegedly helped to orchestrate the fake electors component of the alleged election conspiracy. Joining me now, very excited, Joyce Vance, former U.S. attorney, law professor at the University of Alabama, and co-host of the Sisters-in-Law podcast, and Charles Coleman, civil litigator, former Brooklyn prosecutor, host of the Charles Coleman podcast, and the best-dressed lawyer that I know today. Greetings to both of you. Very excited. Joyce, I'm going to start with you. So I've been doing my homework. I have a big old document here. I have notes and everything else like that. It looks to me like this is a lot of pages to say, Mark Meadows, you got to stay where you got to stay. What's some of the logic behind this? I mean, it's huge that they're not going to be able to sort of change the venue, but what is the logic behind this judge saying you can't move to a federal statute? You can't move to a sort of federal prosecution?
Well, Jason, it looks the same way to me that it looks to you. I'm reading the same big document as we talk tonight. And this is a great opinion by the judge in the sense that he tells you in the first paragraph of this, I think it's 42-page document, how he's going to rule. And the ruling is that the case remains in state court. And here's the reason. Mark Meadows is a public officer. That means he qualifies to ask for removal. But the judge evaluates the conduct that he is charged with and concludes that it was not part of Meadows' official duties. In other words, not a real shocker here, right? Trying to help your boss steal an election is not part of the chief of staff's official duties in serving the presidency. Sounds like the work of the campaign at best, a criminal conspiracy at worst. And the judge says it will stay with the courts in Georgia for a decision.
Charles, so I'm reading through this. This is what fascinated me, because the argument that trying to overturn an election is part of your job would sort of be like the Manchurian candidate is on trial and say, yeah, hey, look, I was trying to overthrow the government for a foreign government, but I was technically president or candidate at the time. Here's the thing about that. Why does this end up being significant for Trump? I mean, Trump might say, hey, I've got a stronger argument because I was actually president. I was simply investigating what I thought was fraud. Why does this ruling about Meadows probably make Trump's chances even less likely?
Well, Jason, what it does is it squarely puts the question of whether any of this can be characterized as under the official duties of your office to bed. We all knew, as Joyce alluded to, that this was a long shot. Mark Meadows' attorneys knew that this was a long shot. But now that this ruling has come out, it leaves even less room for Donald Trump's attorneys to try and argue that somehow this was in the capacity of his responsibilities as the executive of the United States of America. We all knew that not to be true, but the way in which this decision lays that out makes it super plain, super clear, and really closes the door. If anyone would have had that argument, and I'm not saying that he did because it's very clear, I will repeat, that he did not, it would have been Meadows and not Trump. And the fact that the judge made very quick work of that, as Joyce pointed out, early in the decision makes it abundantly clear that this argument is going nowhere fast. And so Donald Trump should not expect to make any traction with it at all.
So, Charles, I want to follow up on this because this is something I think a lot of people who aren't lawyers don't understand. If this had gone through, if Mark Meadows, was tried federally instead of in Fulton County, would that mean that the prosecutors were different? Would it still be Fani Willis's people? Like, explain what would have actually been different if the judge had ruled in another way.
I'm so glad you asked that question, Jason, because a lot of people have been getting this wrong and not understanding that it still would have been under Georgia law. It still would have been Fulton County who would have been prosecuting this case. The biggest difference, which Mark Meadows was more likely than not hoping for, would be an expanded jury pool. So in Fulton County, as we know, you have a predominantly Democratic jury pool, mainly black. You're not looking at a favorable outcome for Mark Meadows if you are his defense team. And so what you want to do is remember, you need a unanimous conviction for this criminal case. You're hoping that by putting this in federal court, you're going to expand the jury pool, perhaps get someone larger or someone as part of this larger jury pool who's going to be sympathetic to what it is you're trying to do and potentially be a holdout, and maybe you get a mistrial. Maybe something else happens because you don't have very much to go on in terms of legal strategy. That was the biggest difference between moving this. I mean, there are some procedural things that are going to differ in federal court versus state court, undoubtedly. But in terms of the substantive difference, that was the biggest difference that Mark Meadows was likely hoping to have happen for him by trying to move this case. But it wasn't going to work out from the beginning. And now that we're here, we all know that to be true.
Joyce, I want to turn a little bit to all of these additional names that we found out that, apparently prosecutors were sort of interested in. They ended up not getting indicted. What's the significance of that? How does that end up happening? How do you have someone who's like, oh, my gosh, you're terrible enough that I want to put you on the list, but you're not terrible enough that I actually want to indict you, but we're still going to release the fact that you were part of this investigation? How does that happen? And how can someone be someone that the grand jury wanted to indict but just didn't have time to, didn't have space? Explain that to us.
So this is such a great question, Jason, and it goes back to the conversation that you and I had back when the Georgia Special Investigative Grand Jury was doing its work. Georgia has this unusual process. There's one grand jury that investigates, and it's very unlike the typical process where prosecutors like Charles and myself might prepare an indictment, take it to a grand jury, and ask them to indict. And while that grand jury needs to only have probable cause to issue the indictment, Charles and I know we have to try that case in a courtroom. We've got to have proof beyond a reasonable doubt. So we don't ask the grand jury to indict until we have that level of proof. This grand jury, the Special Investigative Grand Jury in Georgia, served a very different function. They were only trying to decide whether there was reason to proceed, a much lower standard, right? Probable cause, not proof beyond a reasonable doubt. So they did have this much longer list of people who met that lower standard in their view. And of course, that became Fani Willis's task, and perhaps why there were months between receipt of this report and the final indictment, so that they could determine who do we have sufficient evidence to get a conviction on when we go to trial. A much different task than the one that the special grand jury faced.